In this session, we are going to discuss about membership in a company. Now, members become the most important people or persons to get a company going or administer the company going. So, in this session, we are going to discuss about how a person can become a member of the company, what is the difference between a member and a shareholder, and what exactly does it require for a person to become a member, and how can he withdraw his membership from a company. Now let's see what exactly is the meaning of a member and a shareholder. So if a person has its name entered in the register of members of a company, then he is known as a member. Now, the same question, and a question arises as to who a shareholder is when we look at a factor with respect to shareholding. Now, shareholder is a person, just like how the name suggests. He's a person who holds shares in a company. Now, as far as a company which is having share capital is concerned, member and shareholder becomes kind of synonymous. There's not any much difference between the two. But in case of companies that does not have a share capital, that is when the question arises whether the person is a member or a shareholder. So we'll see what exactly is the difference between a member and the shareholder. Now, as far as a member is concerned, a registered shareholder is a member of a company. So, a registered shareholder means he has his name entered in the register of members. So, that is why a registered shareholder becomes a member of a company. A registered member may not be a shareholder if the company is not having a share capital. So, even though the member is a registered member, because there is no share capital for a company that is not having any share capital or that does not issue shares, then he cannot be called as a shareholder. In case of a legal representative of a deceased member, okay, as far as a legal representative of a deceased member is concerned, the legal representative of a deceased member is not a member until he applies for registration. So just because a member is deceased doesn't mean that the legal representative would become the member of that company the next day of the death of the member. He has to apply for registration. Unless and until he informs the company about the death of the person and he applies for registration, his name is not entered in the register of members. So as long as this is done, even though the legal representative is legally holding the shares of the company, because his name is not entered in the register of members, he'll still be not he would be a shareholder, but then he cannot be called as a member of a company. Legal representative of a deceased member is, however, a shareholder because, of course, he's holding the shares of the company. Same applies to transfer of shares. So, transfer of shares, even though the shares are transferred from one person to another, unless and until the transferee does not apply for registration or does not get his name entered in the register of members, the transferor's name would remain to be the member of the company. So transferor, even though the transfer has happened, the transferor's name would remain as long as his name is removed and the transferee's name is entered. So that also suffice to the difference between member and shareholder. Who can become a member of a company? Now, these parties can become a member of a company. So, basically, the rule here is any person who's competent to contract is eligible to become a member of a company. But there are certain provisions with respect to these people. Now, as far as a minor is concerned, we know that the general rule is the minor is not competent to contract. So, as far as a minor is concerned, he doesn't have the capacity to contract. But courts approve to cases wherein the minor is a member of a company after getting the approval of his guardian. So the guardian has to get into a contract, into an agreement with the company, and in that agreement, it has to specify that the minor is going to be the shareholder and the shares that is allotted to the minor is fully paid up. So in this case, the minor can become a member of a company even though he is not competent to contract. So number one, there has to be an agreement that is signed by the guardian with the company, and the shares that the company is allotting to the minor is fully paid up. So in that case, the minor can become a member of a company. Now, as far as insolvents are concerned, an insolvent cannot become a member of a company because the same case applies. As far as an insolvent is concerned, he's not capable, or he doesn't have the capacity to get into a contract. But if an insolvent's name exists in the register of members, so he has been a member before he became insolvent. Okay, so in that case, his name cannot be removed just because he is insolvent. So as long as the official assignee intervenes and gets his assets sold, if his name remains in the register of members, then he would continue to become a member of a company. Now, in third case, partnership firm. As far as partnership firms are concerned, partnership firms are unincorporated associations. So, for the same reason, a partnership firm cannot become a member of a company. But the members or the partners of the partnership firm can hold shares in the company. So, the membership of the partnership firm can be held by the partners of the partnership firm. So the membership can be held in the name of the partners of the partnership firm. Now, in case of foreigners can become a member of a company, but it has to get the RBI's approval through the FEMA Act. So, if that approval has been received by the foreigners, the foreigners can become the member of a company. But in case wherein the foreigner belongs to a company where India is involved with, then the foreigner becomes an alien enemy. Then in that situation, the foreigner cannot. He ceases to become a member of a company. Then in case of company, a company cannot become a member of itself. Okay, so if there is a company, so a company cannot become a member of that same company. Instead, it can become member of other companies, provided there are provisions approving the same in the memorandum of association. So these are the parties who can become a member of a company. Now, what are the different modes by which membership can be acquired? The first mode is membership by subscription. So every subscriber to the memorandum of association is supposed to hold shares in a company. So if you want to subscribe to the memorandum of association, then membership can be acquired by subscription. Number two, membership by application and allotment. So that is the most common way by which membership can be acquired in a company. So when the company is going to issue shares to the public, then in order to purchase first-hand shares, the prospective shareholder can make the application or pay the application money. And if the company allots the shares, then he would automatically become a member of a company. Now, third situation is membership by transfer. So when the shareholder is transferring his shares to another person, then the transferee when the transferee purchases the shares from the transferor, then automatically he becomes a member of the company. The membership by succession. Now, suppose a member of a company has died, then automatically the rights that he has on the shares gets transferred to his legal representative. So in this case, the legal representative acquires the shares by succession. So that is what you mean by membership by succession. So next point is membership by beneficial ownership. So it has been entered in the register of members that this person is the beneficial owner of these equity shares. Then in that case, we can say that the membership has been acquired by beneficial ownership. So in the register of members, this has been specified that, okay, this person is the beneficial owner of the shares. Then we can say that membership has been acquired by beneficial ownership. Membership by qualification shares. So if a person wants to become a director of a company, then in that case, he's supposed to acquire some shares of the company. So this shares that has been acquired is known as qualification shares. So just because he's been qualified or he has been selected to become the director of the company, he's supposed to acquire the shares of the company. So in that case, membership by qualification shares applies. Now, what are the different situations by which a member ceases to become a member of a company? So that is what is meant by cessation of membership. So basically, there are two modes by which cessation of membership happens. Number one, act of the parties, and number two, by operation of law. So let us see what these points are. So when cessation of membership is done by act of the parties, number one, this is done when he transfers his shares to another person, when the shares that the shareholder is holding is forfeited by the company, if the company sells the person's shares under some provision in the articles. So the company is selling the shareholder's shares by some provision in the articles. If the member rescinds the contract to take the shares in ground of any misrepresentation in the prospectus or on the ground of irregular allotment, then also we can say that it is an act of the party. If redeemable preference shares are redeemed, so when preference shares are redeemed, then the preference shareholder no longer becomes a member of a company. If the shareholder surrenders his shares wherever surrender is permitted, and if share warrants are issued to him in exchange of fully paid shares. So these are the situations by which a member's membership ceases because of his own act. Okay, now let's see what are the points that come under cessation of membership by operation of law. Number one, in case of insolvency. So in case of insolvency, when a member becomes an insolvent and the official assignee takes up the assets of the person and sells off the shares that the person is holding in order to pay off his debts. So in that case, there is operation of law that is happening, and the member ceases to become a member by operation of law. On the death of the member, of course, when the sale of shares is in execution of a decree of a court. Okay, so there is a decree from the court saying that the shares has to be sold by a shareholder. So in that case also there is operation of law that is applied. And when the company is being wound up, so when the company has been wound up, then also there is operation of law that is happening. So the existing shareholder ceases to become the member of a company. So that's all for today's session. Thank you so much.